This is All India Radio. In the program Spotlight, we now bring you an exclusive interview with INDEVAR Pandeey, Secretary, Ministry of Women and Child Development, on the recent major policy initiatives. The interviewer is Aditi Tandon, journalist.
The historic Juvenile Justice, Care and Protection of Children Amendment Act of 2021 prioritizes children in the administration of the country for the first time. In fact, when Women and Child Development Minister Ms. Smriti Irani had piloted the bill in Lok Sabha, she had actually said that we cannot wait for children to become victims and that we have to be proactive in protecting them. One of the major aspects of this act is easing rules under the adoption laws of the country. So, Mr. Secretary, in light of Prime Minister Narendra Modi's mission and vision of ease of living across all sectors, what efforts have been made by the Women and Child Development Ministry, especially with respect to the adoption processes, which are very cumbersome and parents have to wait for endless days to actually get the child home?
There have been 2-3 key changes which have been made in the adoption regulations. One of them relates to where the adoptive parents who adopt a child in in-country adoption, that is within country India, and they are later required to move to a foreign country because of their work or other requirements. At present, there is a mandatory period of 2 years post-adoption when they cannot leave the country. Now, this was creating problems for many people who have adopted a child. Even if they get a better opportunity abroad, they can't move out because of these restrictions. What we have done now in consultation with MEA, that if such adoptive parents want to move to a foreign country within that mandatory period of 2 years, then in that case, 15 days before they move to the new location, they can inform the concerned Indian mission in that particular country that they will be coming with this child, and it will be the responsibility of Indian mission to monitor the child and the family there in case of any requirement. So this ensures that the child is protected, there are no issues with child's protection.
So in place of 2 years, how much does this duration get shortened after these changes?
Theoretically speaking, you can move after 15 days because 15 days is the notice period when you intimate our mission abroad. So after that you can travel abroad for work or any other assignment in that way. So that's the minimum period.
So will there be any process whereby you will issue no objection certificates to such adoptive parents?
They will just inform CARA as well as the Indian mission that they are moving with child because of these reasons. That's all. Nothing beyond that will be required.
What actions are being taken by the WCD Ministry with respect to the MHA notification recently on prospective adoptive parents, and also with respect to the fact that there are certain discrepancies in adoption processes in the country, especially with respect to the Juvenile Justice Law, which CARA operates and regulates, and the Hindu Adoption Act?
Presently, inter-country adoption is governed by 2 key things. One is the regulations of CARA, which have been framed under JJ Act, and secondly there is a Hague Convention, which is basically for prevention of child trafficking. The countries which are signatory to Hague Convention, if the people from those countries want to adopt a child from say India, they'll first check the home conditions. It's called home study report, the Indian counterpart. So their social security team will go and see the place where these prospective adoptive parents live, whether they are mentally and physically and economically capable of handling a adopted child. So then they give a sort of no objection to CARA, yes, they are perfectly fine, and if they adopt a child, we'll be able to give the visa and other things. Subsequent to that, when they get a child from India, based on that, and then CARA does all those home study and other about the child, and then the child is through a process adopted by such parents, then CARA will give the NOC and then the child can be taken out. But in case of Hindu Adoption and Maintenance Act, there was an issue. Regulations like Hague Convention, there is a particular clause, Article 37 in the Hague Convention, which says a country may have 2 or more systems of adoption. So CARA till now were only handling the JJ Act adoptions, but they were not giving NOC in case of HAMA adoptions. They say we don't know whether it is properly done or not that. So that was a grey area where there was no regulatory vacuum in true sense. We took up the matter with Department of Legislative Affairs, which is the nodal department for HAMA, and they said that Ministry of Women and Child Development should direct CARA to frame regulations in this regard, and they authorized us to frame regulations. So based on that, CARA has now framed these regulations, and these regulations will ensure that adoption process which is done in Hindu adoption will be now be certified by the district magistrate that adoption has been done as per the standard protocol of the Hindu Adoption Act. At the same time, CARA parallelly will move the country where the child is supposed to go. These are for inter-country adoptions. So with their authority, nodal authority of counterpart of CARA, that these are the people, they want to take a child, they have already adopted under the Hindu Act, and whether they are fit enough. So they will give no objection from their side. These people are good enough, they will be able to take care of child, and then once they give the NOC, and from DM side a report comes to CARA saying that the adoption has been properly done, then the child can be taken. Let me tell you, there have been several cases where people have been fighting cases in High Court, Supreme Court for such long time, and because of this vacuum, these children are held up and their parents who are held up because of mandatory those 2 years clause in, they cannot take the child.
So this will really ease inter-country adoptions by removing the Hague Convention issue, the lack of clarification around that
Absolutely.
issue, which CARA had.
We have taken care of issues related to Hague Convention. At the same time, we have also made a process for HAMA, which is in a way as steady as it is in case of JJ Act, because DM is also the nodal authority for JJ Act in JJ Act adoption also. So he also becomes for HAMA, he certifies that the adoption has been done strictly by the guidelines of the HAMA.
What about with respect to within the country adoption? Because there also there have been many challenges. A lot of parents actually say that they've had to give preferences with respect to 3 states, and they do get tied down because of that, and then sometimes a child from one region is really relocated to a culturally alien place within the country. For instance, some child from northeast could land up in Kashmir, and then there are cultural and language issues.
This is a very valid point. In fact, in JJ Act, in the section 3, it is mentioned clearly that children as far as possible should be adopted in their social cultural milieu. But somehow or other, when the system was designed, it has been done in such a way that even for in-country adoption, a person is supposed to give the options for 3 states. Now these 3 states may or may not be his home state. That is anomaly in the regulations. So we are going with the spirit of the CARA, and we'll be making changes in the regulation. It has been approved in principle, but there will be some time when it will be issued. We'll make sure that first priority will be for people of the state. Say if a child comes from Assam, so first priority will be people from Assam who can adopt it. It's only when you don't get prospective parents from that particular state, then the child will be open for all India adoptions. And in case, because of certain reasons, there are no takers even in all India adoption, then only it will be open for the NRIs, OCIs and the foreigners for adoption. So it's a more scientific way of putting children in new homes, I would say.
Minister Irani, at the time of passage of the JJ Act, had made 2 extremely valid points in Parliament. One, she had said that a kind of child shelter home audit was conducted across 7,000 childcare institutions in the country, and shocking results came out. One of the things that she mentioned was that only 29% of these childcare homes were actually found to be registered under the JJ Act, whereas the mandatory registration clause came a long time ago. Mr. Pandey, what is it that the ministry is doing now to ensure that such homes which are in violation of the JJ Act actually fall in line? Because you've also made district magistrates in charge of child protection at the district level, which is a landmark and revolutionary step in the area of child protection.
Actually, with an amendment to the JJ Act, we have now come to a situation where there is a clarity about how children's care and protection will be handled at the district level. Till now, this was a very diffuse kind of responsibility, even though we had the institutions, but the lines of responsibility and authority were not very clearly delineated. Like say child welfare committees, they used to enjoy the power of first-class magistrate. But then there were no guidelines for how the members of the CWC will be appointed, what should be their eligibility condition, there should be some bar on people who can become the members. In fact, when we were doing the survey, we came to know that in several child welfare committees, the very promoters of the child care institutions were the members. Now this is a clear case of conflict of interest. So we are taking out all these people who have conflict of interest in the system. Someone who is running a child care institution cannot be a member of child welfare committee because there is a clear-cut conflict of interest. So these things we have brought, and DM has been made the nodal officer at the district level. Now this will ensure that all institutions will be looked after at some level by a fairly senior officer, and they will be inspected, and if there are issues, will not hesitate to cancel the license of such institutions.
Mr. Pandey, a very important national conference was recently hosted by WCD Minister Smriti Irani in Kevadia in Gujarat, only recently, and a lot of issues the state governments also flagged. What, according to you, was the principal outcome of that conference, and how do you take those concerns of state governments forward?
See, this was a conference of State Ministers of Women and Child Development and the Secretaries of the Departments, Women and Child Development and Social Welfare. So this was a 2-day conference, and basically we first made presentations about how we are restructuring our schemes. Now we are putting our schemes in 3 verticals. One is Mission Poshan, where all nutrition related schemes will be put. There will be one Mission Shakti, where all schemes related to women will be put in one place, and Mission Vatsalya, which is for all the children. So we gave our presentation, then we took the feedback of the states to what further you want, what changes you will suggest and all that. And we also discussed the JJ Act amendment which has been passed in the Parliament in great detail in this conference. For the first time in probably, I'll say, history of any legislation, we told the states, now you have this amendments to the Act. Normally what happens, central government makes a model rules and it circulates to the states for their comments on that, and they said you draft the rules as per what you feel will be the best possible solution to the issues, and then we'll take those forward and we'll also see that how we can incorporate your suggestion at beginning itself. We also told NCPCR that you also do your bit. So NCPCR has prepared a set of model draft rules, and some of the states have also given their suggestions ki what should be there. Now with this we'll work and we'll frame a model rule and then subsequently consult with all the stakeholders. So consulting states upfront is something, even for our schemes, we have consulted them before the guidelines have been issued. Normally it doesn't happen. So that way it's a very proactive step.
One very important issue before your ministry, Mr. Pandey, is the welfare and the rehabilitation of COVID orphans. The Prime Minister Cares program is taking care of this aspect of child health and mental well-being. What is it that you are doing going forward? Because we learnt recently during the Parliament session that there were some COVID orphans identified. States had sent you lists.
We have made a end-to-end digital portal for PM Cares for Children, which will provide all facilities to such orphans at one place. The child or their guardian do not have to go to any other place for any benefit. The benefits will be, if you see from the child's perspective, he'll get a certain amount of money every month till he is the age of 18 under our child protection scheme, which is 2,000 rupees at present and likely to be enhanced to 4,000 shortly. All education for him will be free till he is the age of 18. It's only for higher education that he'll have to pay. We'll be mandatorily, depending on where the child is placed, giving admissions to the Kendriya Vidyalaya, or for in case of women, Kasturba Gandhi Balika Vidyalaya, which are residential schools, so boys also, depending on their requirement. But government guarantees that they'll be given admission whether the seats are there. Even if extra seats are to be created, they'll be given. If there are 2 children, say 2 brothers or 1 brother, 1 sister in such a situation, we'll try to keep both of them in one place. So education is assured. Medical through National Health Authority will make sure that he is covered under Ayushman Bharat Yojana with a insurance of 5 lakhs. His financial well-being, Honorable Prime Minister had announced that the children will get 10 lakh rupees at the age of 23. There was something about 23 which people didn't get that time. See, up to the age of 18 years we are paying from child protection home, and government will give the child so that he can go through his study and all is free. And this money we'll put in a new scheme. It's called PM Cares for Children Savings Scheme in Post Office. This will be a small savings scheme. Based on the age of the child, we'll put a certain amount which will become 10 lakhs when the child becomes 18. This money will be put in a monthly income scheme, and then from there he'll get a stipend till he's the age of 23. Between 18 and 23, if he goes for higher education, we'll either, if there are scholarships in the departments, we'll ensure that. Otherwise, if he takes a loan for higher study, PM Cares will pay for the interest on that. Child will only have to pay the principal part of the loan later on. We are also concerned about safety of children. We have put that it will be a joint account with the district magistrate, so that people cannot allure him in parting with his money till such time he is a major and he can understand his well-being.
Thank you so much for your time.
Thank you so much.
You were listening to an exclusive interview with INDEVAR Pandeey, Secretary, Ministry of Women and Child Development, on the recent major policy initiatives. The interviewer was Aditi Tandon, journalist. This program was produced and presented by the News Services Division of All India Radio.